Dealers must file a registration with Consumer Affairs, post a notice of the dealership that they are charging closing fees, disclose the fact that they were charging closing fees on the contracts and include their closing fees in the advertised price of the vehicle. The operative word is disclosure. And basically what we're saying is that it defines closing fees, lists what can be considered in calculating closing fees, and reinstates the South Carolina Department of Consumer Affairs as the enforcement agency of the closing fee. So basically, generally, we've had a lot of discussion. There was a lot of negotiation and talk as we went through this. We've had the trial lawyers, we've had the automobile dealers, we've had consumer affairs, all come together in a lot of conversation to reach this agreement, and I believe the operative term is disclosure as it relates to all of that. That is basically the amendment.
Any questions about Amendment 1? All in favor say aye. Opposed, ayes have it. Amendment 1 is adopted. Go to reading number 2. March. Go Ben. Call Hunter. 2. All right, Ms. Dodge, we're on Amendment 2. Representative Bond is recognized on the amendment.
Thank you, Mr. Speaker. Ladies and gentlemen, just very briefly, I think this is more of a correction than anything else. What this amendment does is strike the language and the preparation, reconditioning, and cleaning of the motor vehicle from section 37-2 307B. If you'll read later on in the legislation, the different things that a dealer can charge a closing fee for, the preparation, reconditioning, and cleaning of the motor vehicle is not included. So if it's not included in that list of things that they can charge for, we certainly need to take it out of this particular section. I understand that many of you have been contacted by the Automobile Dealers Association, and they have certainly asked for no amendments, but I just want everyone to know that I have spoken with them. I believe you can do the same if you wish, but it's my understanding that they have no concern with this particular amendment. To try to clarify, I just don't want us to have one section completely with another section, and I certainly don't see where the reconditioning and rehabilitation of the vehicle has anything to do with the closing cost. So, Mr. Speaker, I do need to adopt an amendment.
Well, Ms. Calhoun has a question. Ms. Calhoun is recognized.
Thank you, Mr. Speaker. Mr. Ott, would you be surprised to know that I just had a conversation with that powerful chair of LCI, and that he says it is just refurbishing, that he supports it and has no problem with that?
Yes, ma'am. I would hope refurbishing include.
Well, let's just go, Mr. Ott, with the word refurbishing. And did you know that when you went in, you might want to step away from the podium? Thank you, Mr. Speaker.
I love my desk mate.
Ms. Bowman is recognized for a question. Ms. Bowman.
Ms. Dodd, so you're taking out, when a dealer specifies what goes into the fee, you're saying through your amendment that he can't add refurbishing. Is that basically what you're saying?
Yes,
He
sir.
can't put that in the $299, and dealers are good with this?
Yes, sir. Like I said, if you read further in the bill, where it specifically says what a dealer would include in coming up with this closing fee cost, that language is not included. So I'm just trying to make it very consistent throughout the bill that if we're not going to allow for it, where it specifically states what they can charge for, we certainly don't need that language in another part of the bill.
Any questions? Any questions to adopt Amendment 2? All in favor say aye. Those opposed? Ayes have it. Clerk will read.
Number three, Rutherford, Walton Cloud, number 3.
What's in the files right now is on Amendment 3. That's in the file.
Good morning, ladies and gentlemen. Good afternoon. This is about this relevant. But fundamentally, except the committee, member number one, the committee amendment, to eliminate the entire preamble, in other words, all of whereas clauses. Now, let's give you a little background here. As you pass through life in the United States of America, you all know that an ex post facto law is unconstitutional. Now, an ex post facto law is applicable only to criminal offenses. That's in the federal constitution and the state constitution. No ex facto laws which will punish you for something that took place in the past. Now, there is no constitutional amendment proposed proposition in the state constitution or the United States Constitution which outlaws retroactive legislation. So it outlaws things which have taken place in the past that you may have done. And a neat little exception here. Anything relating to taxes, the federal and state government does and forgive and from time to time. So frequently you have a retroactive provision relating to the payment of taxes. But for that, there's a very strong proposition of law which says with respect to civil conduct, your behavior, retroactive application does not apply. Now, I could probably quote several lawsuits from the state Supreme Court and the United States Supreme Court which outlawed retroactive activity which is not criminal. Now, what we're talking about here, you all know you've all been contacted by a multitude of automobile dealers. I've got one in Newberry who's a good friend. He asked me to co-sponsor this legislation, and I respectfully declined. Now, simply stated, the amendment you passed first another time. The committee bill is okay with one exception. And that one exception is all those whereas you saw, total about 57, transmit the message that it's okay for this bill to be retroactive in application. Now let me tell you about a little pattern that you see from time to time. From time to time, people, organizations, businesses conduct themselves in a manner which costs them some money. And from time to time, people show up to the State House and they say, the Supreme Court made a decision, we don't like it, we want you to change the law so that we can't be accused of that conduct in the past. It's not a good idea at any time for courts to make a decision and then the loser to waltz into the State House and say, my friends, we cannot do this, we cannot survive. It is impossible to have this provision. And the legislature decides, well, I think maybe we ought to give them a little insulation. Let's protect them from what they have already done and what the courts have already made a decision on. In other words, that's when you go from preaching and meddling. Go into meddling, you need not meddle in that kind of activity. So this bill, this amendment right here, by which I'm speaking, Mr. Rutherford is the primary officer, drafted me call. The good issue is that if these, whereas it's staying in this bill will have many messages saying that it is okay for it to be retroactive. You as legislators need to remember, we don't have any ex post facto laws in the United States with respect to criminal activity, and we have very, very, very few, taxes being one of them, regarding the retroactivity of other past conduct. So you want to pass a clean will not be retroactive in any way. We're trying to prohibit the retroactivity of this bill is about to vote on. Now, my amendment is cleaned it up. So I would urge you, this is not some sort of activity just to oppose something for the heck of it. We need to have a judicial system which works well, and we need to have a code of laws which works well. And I urge you to vote to eliminate entirely any question about retroactivity about House Bill 4548. Thank you very much.
Everybody give up voting. Any question? Is the adoption of Amendment 3? Mr. Norman moves to table Amendment 3. All in favor of tabling Amendment 3, say aye. Aye. Opposed? No. Ayes have it.
Amendment 4 is Bamberg, Rutherford, Walker, Brown. Bamberg, Rutherford, Walker, Brown.
On Amendment 4, Representative Bamberg is recognized.
Thank you, Mr. Speaker. All that this amendment does is, the preamble and everything that's in there leaves room to argue whether or not the bill is retroactive. I think that we just need to be careful and anticipate potential murky waters. I would think it's the intent of this body to allow this bill to work retroactively. And that's all this amendment says, is that, it specifically is only going to apply to causes of action that arise as of the date of the signing. Can't retroactively go in and change anything. We have a system in place, and as we know, cases are litigated and things of this nature. Reaches a jury decision, that decision goes on appeal. It's not the place of this body to go in and undo jury verdicts. I think that undermines the integrity and the separation of the branches of this government. So with that, Mr. Speaker, I will move for passage.
Ms. Bamberg gives up the podium. Mr. Norman moves to table the amendment. Any questions, please? Give it up, Ms. Bamberg. Recognize Mr. Norman. Any questions? Tabling motion. All in favor of tabling Amendment 4, say aye. Aye. Opposed? No. Ayes have it.
No further amendments on 45, 48. No further amendments on 45, 48.
Remember, on a voice vote is not allowed to 65 or 6 of you is the multitude who vote. Now, any questions? Pending question is the adoption of House Bill 4548 as amended. Roll call is required in order. We'll vote on the board. Any questions? Second reading, House Bill 4548 as amended. Dr. Ridgway, you have an announcement for the roll call? Good. know you're 98%, House Bill 4548 is beginning to proceed second reading. Because in the grand issues will be recurred before the hour. All in favor say aye. Opposed, no. Clerk read.
Mr. Green Brown expressed concern for the passing of Clifton